Good afternoon. Can you hear me?
Yes, I can.
Yes.
Sorry, ma'am, can you hear? Can you say something, please?
Testing.
Again, the other comes there. She's not responding.
Hi, can you hear me?
Council, thank you so much for joining us today via Zoom. I apologize for the difficulties that we just experienced. So welcome to an oral argument session, the 6th District Court of Appeal. The argument that we're taking up right now is Arlington Financial Consultants versus U.S. Credit and Stephen Galvin. As I'm sure you know, each side is permitted 20 minutes of argument. Council, for appellants, you're also permitted a rebuttal period. We usually reserve 5 minutes. If you would like a different increment of time, please let us know. Is 5 minutes acceptable?
Yes, Your Honor. 5 minutes would be great. Thank you.
Before you begin, I'll just introduce myself. My name is Judge Nardella, and joining me on the panel today are Judge Brown and Judge White. Council, whenever you're ready, you may begin.
Thank you, and may it please the court. My name is Matthew Lito, and I represent the appellant Arlington Financial Consultants, LLC. The issue before the court today is whether the trial court erred when dismissing a claim for fraud in the inducement against Stephen Galvin, an individual, based upon the independent tort doctrine and the existence of a general merger clause within a contract between Arlington and Mr. Galvin's company, USCI. Our review of the case law indicates that the court did err in dismissing the claim with prejudice because Arlington didn't. I'm sorry, if I heard something.
No, counsel, continue.
Oh, okay. Arlington did state a cause of action. Now, by way of background, the amended complaint expressly alleges the existence of a misrepresentation of present fact that was made to Arlington to induce them to enter into a contract with USCI by Mr. Galvin. And on the record of page 336, the allegations in the second amended complaint are in paragraphs 33 through 35, and is expressly alleged that Mr. Galvin repeatedly and expressly represented that USCI had contracts in place with various lenders that allowed USCI to access to funds in excess of $350 million for use in Arlington's platform, and which would fund the home improvement projects that Arlington's platform allowed. And then we also allege that Galvin further stated that the funds were readily available for disbursement and that he had, quote, received approval from their lending and secondary market partners for the credit underwriting process. And as a result of these statements by Mr. Galvin, Arlington then entered into the contract with USCI. So with respect to the independent tort doctrine, which was the first basis for dismissal of the fraud and the inducement claim, I think the case that really is the centerpiece of our argument, I believe is the most analogous to the claims that we have, is the Costa Investors versus Liberty Grand case, which is a fourth DCA case out of 2022. And the first issue that the Costa case states is that the principle of the independent tort doctrine only applies, quote, only applies to the parties to the contract. Now, Mr. Galvin is not an independent party to the contract. He merely signed on behalf of the company. So on that basis alone, the independent tort doctrine should not apply. But also,
Are you aware of Vesta Construction Design versus Lodgepitz? It's a 50 CA case about the economic loss rule and the same principles being discussed.
I am aware. I recall the Vesta construction case, not from work on this particular matter, but just in the past. Yes, I do know the Vesta matter.
So in Vesta, Judge Lawson talks about the economic loss rule, which, similar to the independent tort doctrine, is a boundary doctrine to keep contract from being swallowed at the sea of tort. And when it's being applied to an employee there who is not a professional, he finds that even though the argument's being made that the employee was not a party to the contract, that you cannot circumvent then the economic loss rule, here the independent tort doctrine, by suing the employee for performance. I understand here your argument would be that you're not suing for performance of the contract. What you're actually suing for is fraud inducing the contract, all of which predated the contract. But if we were, and I know your argument doesn't stand alone on this basis, but if we, I guess the better question is Vesta wrong in their analysis? Is Costa correct that all that matters is we look to see who a party to the contract is, and if the party is not being sued, it's not a party to the contract, they're just performing on behalf of a party to the contract, that these doctrines don't stand in the way?
From what I recall of Vesta, and again, it's been a little while since I've read the case, I do believe that predated Tiara, which got rid of the economic loss doctrine. But with that being said, I don't think the analysis just rises and falls only on the fact that he's not a signatory to the contract. That's not my reading of Costa either, because Costa does go a little further as well. And Costa then says that really what the court should do is analyze the complaint to determine whether the evidence was sufficient to show that fraud occurred and whether the individual could be liable when he actively participated in the fraud. And it goes back to the statement of, it's a false statement of fact. It must be of a past or existing fact, not a promise to do something in the future.
So here the argument would go that it's separate anyway, so it doesn't really matter.
Right. This is exactly right. I mean, whether he's a signatory or not, I actually believe that we could sue the company for fraud, although they're in bankruptcy. But because this is a statement of an actual present fact at the time he made the statement before the contract was entered into, that's why it's not a simple fraud in the performance type of issue, which would, I think, be barred by the independent tort doctrine. And that, I think, is also one of the distinguishing features in Peebles and Island Travel, which are cited by the appellee. I'm sorry, yeah, by the appellee, because in those cases, you have fraud in Peebles that induced somebody to continue performing a contract already, was already in place. And in Island Travel was also basically it was a breach of what the term was of a future conduct of the parties and how they were going to split certain distributions. Here, the contract just says, okay, we're going to provide this financing to you. But the inducing factor that led to the execution of the document or of the contract was we can do it now. And it's not only that we can do it now and we have these lenders in place, but it's that we already have, quote, approval from their lending team and secondary partners to go ahead and fund these $350 million worth of loans. And as we know from the other attachment to the amended complaint, that wasn't true, admittedly, at the time that it was made. And these are all, again, pre-contractual statements that induced action on behalf of USCI. And, I think one of the interesting points about Costa, which in Costa, there actually was the representation in the contract itself that formed the basis for the fraud claim. So in Costa, they actually signed the agreement and a borrower certificate saying that this property was owned by the entity that was borrowing the money that was going to be the collateral for this loan. That was the false statement that formed the basis of the fraud claim that was permitted to proceed based upon the evidence. I mean, the actual fraudulent statement made by the non-party to the agreement was in the document, which was also formed a breach of contract claim against that entity. And I noted that in the appellee's response, they say that, well, Costa, there was no breach of contract claim that was raised. But I mean, in the opinion itself, it indicates that there was a subject breach of contract claim against Liberty. So both of those claims were permitted to proceed together, given the facts that were at issue in that case. The same issue or the same type of result came up in the Pruitt case and also in the UKEN case. And I think, again, the issue that we're really focusing on is, okay, was there a present fact that was alleged that can form the basis of fraud? And if a corporate officer who is not a signatory to a document participates in that fraudulent conduct, that individual can be held liable. So that is what COSTA stands for. That is also in Pruitt. The distinguishing factor in Pruitt was this person said, I have enough money to operate this racing team now. And they make the analogy in Pruitt where they distinguish between fraud in the performance and fraud in the inducement, where somebody says, I have $10 in my pocket right now to pay for lunch. That's a present fact, where it would be fraud in the performance if they say, well, I'll buy you lunch in the future. So here we're dealing with all present facts that were expressly represented by Mr. Galvin, which permit a fraud in the inducement claim to proceed. And that's what we've alleged. Another issue that's raised in the order, really, it goes to the merger clause that's part of the contract. So what the trial court found was that the existence of this general merger clause also eviscerated a possibility of having a fraud in the inducement claim. But first of all, the appellee doesn't really address the cases that we raise in our brief as to why the merger clause is inapplicable. I mean, this goes back to the Mejia case where a typical merger clause does not stop or prevent a fraud in the inducement claim from going forward. The only types of contractual provisions that would do so would be a specific provision that says we are not going to sue you for fraud for representation. So a non-reliance clause, which we do not have present in this contract anywhere. And again, the appellee didn't really address the merger cases that we raised in our brief, which in our view, that means they waived their argument on that. Or maybe they recognize that, Mejia really is the controlling case and the merger clause is really of no moment when it comes to a fraud in the inducement matter. So when it comes down to it, the main cases that are cited in opposition to our brief really deal with issues of either, again, future performance, which certainly could be barred by the independent tort doctrine, or cases where there's, for example, in the Sun Life case, where they found that, first of all, these were two parties to the contract, but the court in Sun Life found, well, they're literally alleging a fraud, which is the contractual provision to check on this non-contestability items on these life insurance policies. That was specifically in the contract. And because it was specifically in the contract between the parties, there was no fraud that was found. In addition, in the Inspiration case, the court, although they found it was a close call, found that there was no fraud in the inducement that could be alleged because the misrepresentation, aside from some puffery in the difference, was exactly what the party contracted for, where they said, we're going to give you this billing software and we're going to do X, Y, and Z. That was the alleged misrepresentation, which exactly was the contract that they signed. We don't have that situation in this case, making all of those cases distinguishable. So at the end of the day, what it comes down to is we've alleged a present fact that was misrepresented to USCI, which induced them to enter into the contract. And that is really the general rule that must be looked at to see whether you have a fraud in the inducement claim versus a claim that would be more of a breach of contract claim, which is future performance. And again, if the panel doesn't have any other questions, we'll rest on our papers for the remainder and we'll just wait to rebut counsel's opposition.
Counsel, you discussed in your initial brief the damage argument.
Oh.
Can you hear me, counsel?
I'm having trouble hearing.
Yes,
In your initial brief, is that better?
I'm sorry, Your Honor, the audio is not coming through.
I can't hear.
Can you hear us now?
Yes, I can hear you.
Yes.
How about now?
Absolutely.
Much
Counsel,
better.
thank you. In your initial brief, you discussed the importance of damage, that they're not identical here. You cite Pebbles that also looks at damage. It's one of our sister courts. Under a prior analysis under the economic loss rule, we would concentrate and key focus on the nature of the damages. Under the independent tort doctrine, I understand Pebbles did it in the 30s. The third DCA has done it, but can you tell me why you think it's appropriate that we look to damage, what it tells us about the independence of the action since they're not identical?
Yes, and yeah, in Peebles and also in the I think the Island Travel case, they both talk about how the damages have to be also distinct for it to get around the independent tort doctrine. So here we have alleged completely distinct measures of damage between the breach of contract claim, which obviously would be stayed because of the bankruptcy, and the fraud and the inducement claim. And it's actually the fact that the contract does not allow for certain damages that would be attainable under the fraud claim, which is the distinguishing feature. The contract allows for certain payments that Arlington would receive. If there's a breach of the contract, that's all they can recover. And there is also a limitation on any other types of damage that are contractually permitted. But the fraud claim doesn't have those types of limitations. So the fraud claim would look for lost profits, which are not contractual, reliance damages, which would not be contractual. And also we've alleged in count 2 of the amended complaint, enterprise damages, which would be the measure of damages if the company were to simply go out of business because of the impact of the financial impact of this.
Understood,
of this
counsel.
fraud.
Let me ask, I asked a poor question. Let me ask a better question.
I
Why
apologize.
why does it matter? Under the independent tort doctrine, which is not the economic loss rule, I understand that there's 2 cases out of the 3rd which look to damages. Our court hasn't spoken on this issue yet. Can you tell me why you think it matters that the damages are not identical in when we apply the independent tort doctrine and whatever formulation you think it has? Why do damages play a key, in your view, a key part in the analysis?
Okay, so my answer to that really is I don't think damages really play a key in it. So, and the reason I come to that conclusion is based upon, again, the Costa case, the Pruitt case, the Yukon case, which all say that the independent tort doctrine, and I'm sorry, there's also one other case that we cited, it's the airline case, I think it's UNC JR. They all say that the independent tort doctrine does not apply when you're not a signatory to the contract. So I don't think it would apply, the damage model would not apply there whatsoever. But if the court were to look at the distinguishing damages, which we would have to show if the court were to follow Peebles and follow Island Travel in that regard, all we would have to show is there is a different measure of damages, because in both of those cases, it was precisely the same measure of damages that were being awarded. I think those are both post-trial cases. And that's not the case here at all. So I don't think the independent tort doctrine in this particular case would apply at all, meaning the damage issue would be inapplicable. But if it did, we have different damages anyway, which still would exclude us from any protection or exclude them from the protections of the independent tort doctrine. And I hope that answered your question, Your Honor. And if there are no further questions from the panel, I'll rest at the moment until my rebuttal.
All right, we'll reserve the rest of the time. Counsel for
Thank you.
Applee, whenever you're ready.
Good afternoon. Thank you, Your Honors, for allowing us to appear by Zoom. May it please the court, Laura Wendell, Weiss Serota, on behalf of the appellees, Stephen Galvin. Your Honors, this really is a breach of contract case. In this case, U.S. Credit, the company, partially performed and then it breached. And when provisions of a contract are breached, the parameters of the claim are defined by contract law, not tort law. Now, fraudulent inducement is into a contract is an exception to that. But what is a fraudulent inducement? It's a trick or it's a bait and switch, but there's no trick and there's no switch when the alleged misrepresentation is made an express term of the contract. And that's what we have here.
Counsel, can you hear me? Excuse me, ma'am. Are the allegations contained in paragraph 33 of the amended complaint in the contract? And if so, can you tell me where in the contract the allegations contained in paragraph 33 are?
I'm just looking at paragraph 33.
Mm-hmm.
Yes, the allegations are in the representation that there would be $350 million worth of damages are in the contract, in the agreement, paragraph, page 1. USCI will provide lenders that can lend on a nationwide basis and that will commit up to $350 million annually for eligible funding of eligible loans.
Sure. I understand that the contract says that they will do those things. But as I read paragraph 33, it states, for example, that Galvin repeatedly and expressly represented that USCI had contracts in place with various lenders that allowed that company to allowed them access to funds in excess of 350 for use in Arlington's platform that would fund home improvement projects, and that those funds were readily available for disbursement. That sounds different.
Yeah,
that sounds different, right? Than I will give you funds. I promise I will give you the funds that I have. The complaint looks to me if we just look at paragraph 33, like they're saying, I have those funds. Isn't that different?
Well, it is different. And the distinction between, I have to concede that it's different. What's alleged is a present statement that turned out not to be true. The contract was breached. What makes it a breach of contract case and distinguishable from the Pruitt case and the Yukon case is that there actually is a contract provision. The present fact, the present statement became a future promise. In the context of fraud is a present statement. It doesn't become actionable, however, when the exact same promise is made in the contract. In Pruitt,
Counsel, what case holds that?
Go ahead.
The cases that they rely on, Pruitt and Yukon, it's silent as to, in each case, the contract is silent as to what distinguishing between present and future. There's no future promise. It's not a present fact and a future fact. It's what's going on in the present and is there a promise? And here there is a promise. in Pruitt and Yukon, there was no promise consistent with the present fact that was stated. And that's why in Pruitt and Yukon, there was a claim for fraudulent inducement. Here, there's no switch. It says it in the contract. That's our position. And is there a case that says,
The counsel,
yes,
you just agreed with Judge Brownlee that there's a difference, and that is the complaint alleges in paragraph 33, a statement of fact that is alleged. We're at the motion to dismiss stage. I'm not saying whether the plaintiff can prove these allegations, but they've alleged that there was a false statement of fact made. And then your argument is, well, it was, I don't want to misquote you, but transformed into a promise. So you agree?
yes. What was,
Counsel?
where is? oh,
Counsel,
I'm sorry.
So you agree that this statement of fact that was made during the communications alleged in paragraph 33, that did not become a representation or a warranty in the agreement? Do you agree that it is not, that statement of fact that was made before the contract did not become, here's a representation of facts in the agreement?
I do not believe it's a representation of fact. It is a promise in the agreement. It is a promise in the provision that I read to you.
And so
Actually, it cites, it's not in the recitals, it's in the responsibilities of U.S. credit. So what case says that if it appears in the contract, it's not fraudulent inducement? Hotels of Key Largo.
well, I'm sorry,
Inspiration.
hold on. I want the case that says if a statement of fact that is false is made before the contract, and that statement of fact is then written as a promise in the agreement, that is not an independent fraudulent inducement claim.
I don't think it's a fraudulent inducement claim. It might be a fraud claim. That's the Costa case. Costa is a fraud case where the term in the agreement itself was false and could not be performed. There is no claim for fraud here. There's a claim for fraudulent inducement. In Costa, the loan couldn't be performed because the collateral for the loan had previously been sold. Representations were made to the contrary, and they were made in the agreement, and that was a fraud case, and the contract couldn't be performed. Here you have performance of a contract and a breach. You have an expectation that the funding is going to chirp along based on the promise, and it doesn't. It's a breach of contract.
Wasn't just to provide. With regard to the fraudulent inducement, it was, hey, we already have this on hand. So we're going to, once it goes into the formation of the contract, we've told you we have it on hand, and now we're going to promise that we're going to pay all of these things to you. That's distinguishable, I think, from what you just articulated.
But the principle of the distinction between fraudulent inducement and contract is, the overarching principle is it interwoven with, is it related to, is it part of performance of the contract? And whether it was past, present, or future, it's the performance of the contract that fails. That's
Well,
the reason.
They could have breached the contract in two different ways. They could have had the funds and then decided not to fulfill their obligations under the contract, or they could have never had the funds and therefore been unable to fulfill their obligation under the contract. Both would result in breaches of contract. One would be a present fact, I think, which is what counsel is arguing. One would be a present fact that is untrue, for which a cause of action may arise that predates the contract obligation. Why is that not? Why is the first example not independent?
I'm sorry, why is it not independent? Because it's the exact same statement that's in the contract. And the contract can be performed without it.
Not.
I mean, in Pruitt, there was no promise that the racing team was funded. It was just an inducement. It was a bait. The performance was on the other side. The contract.
But isn't there allegation that this was a bait?
That's the point, right?
But there's no switch because it's in the contract.
Counsel, how would you distinguish this case from the holdings made by the Florida Supreme Court in HTP Limited v. Linnaeus Areas? And I'm not even going to try to pronounce that last word.
Let me just pull, I believe that in HTP, the distinctions that's made is where the alleged fraud, the alleged fraudulent inducement is interwoven with the breach of contract. I don't think there's any dispute here. There can't be a dispute that it's interwoven with the breach of contract. Now, in this case, it's exactly interwoven, and the terms of the contract say we're going to do exactly what we said we're going to do. We're going to fund these agreements.
Well, let me point you to the language quoted with approval by the Florida Supreme Court when they're quoting the Bankers Trust v. Pacific Employers Insurance Company case. It says one who has been fraudulently induced into a contract may elect to stand by that contract and sue for damages for the fraud. When this happens and the defrauding party also refuses to perform the contract as it stands, he commits a second wrong, and a separate, distinct cause of action arises from the breach of contract. The same basic transaction gives rise to distinct and independent causes of action, which may be consecutively pursued to satisfaction. I'm struggling on how I could
Because
affirm.
it goes on to say that fraud in the inducement is a special case. This is not a fraud case. No, there's no claim for fraud here. This is, had they wished to bring a claim for breach of contract and a claim for fraud, saying that they never had the $3 million and yet they promised it, that would be Costa. That would be a fraud claim. But there is not a fraud claim here. There's an attempt to bring a fraudulent inducement claim, which differs. And it differs because the fraudulent inducement case law looks to whether or not the alleged misrepresentation is interwoven with and inseparable from the contract. That's the broader general principle. I think that it is significant and important that the Pruitt case the representation had nothing to do with performance of the contract. The representation made in Pruitt was, hey, we don't need your money. There's no provision, Pruitt says. This representation did not appear in the contract. There was no promise made in the contract that the racing team would put money in as well. It was an inducement to an investor to put money in, saying, hey, we don't even need your money. That's not what we have here. We have a breach of contract where what was promised in the contract and what was represented before the contract wasn't performed. Had they brought a fraud claim like Costa, yes, then they would have had two causes of action. The contract was fraudulent, and it's a breach of contract and it's a fraud claim, and Galvin was actively involved in the fraud. That's Costa. We don't have Costa here. I think the issue of damages comes second to the issue of whether or not there is a fraudulent inducement claim stated in the first instance. Is there a separate representation that's not interwoven with the contract? No, here there isn't. But as counsel conceded, the count for breach of contract has a different damages clause because the contract itself limits liability. So here the parties have contracted to limit liability. That takes it out of the realm of tort. That the fact that they are looking for whatever these damages are that are called, and I believe that they are contract damages, their losses as a result are, it's a circumvention of the contract. The parties made an agreement as to what the liability would be.
But Galvin never signed that, right? As an individual, he's not signing that and agreeing to limit his liability for any actions taken in furtherance of negotiating that deal. Is that correct? So
well, the contract has a limitation of liability.
but he's not
Hey,
a party to the
let's sue-
contract.
Every time let's sue the CEO for a fraudulent inducement so that we are not limited by the contract. That's what's happening here. The individual CEO negotiates a contract. They talk about what the contract's going to do. They talk about what's going to happen. If every time a CEO negotiates a contract and the contract is ultimately breached, and during the negotiations, they talk about how the contract's going to work and what the term of the contract are going to be, then there'd always be a fraudulent inducement claim every time a CEO discusses what's going to be in the contract and what the terms of the contract are going to be before the contract is made.
I mean, I think that's an overstatement.
Couldn't the limitation of liability specifically refer to the party's officers, directors, employees, and agents as well?
You mean, had it done that?
Right, that's something that could be negotiated by the party.
The contract, sure, that could be negotiated by the parties. But it's the contract is a contract between the entities, right? So it's a limitation of liability between the entities. If the contract were to spell out the CEOs shall never be liable for breaches of the contract. And if they are, this is their limitation of liability, then the CEOs would be parties to the contract. They're not parties to the contract. The other thing that distinguishes this case from cases finding fraudulent inducement, and certainly from Costa, is that the contract was performed. It's alleged in the complaint that the contract was performed for 6 months out of the first year contract term. So the fact that the contract also, the complaint also alleges that the CEO said, we made a mistake. We didn't perform under the contract correctly.
Thank you, counsel. If you want to finish that one thought, but your time has expired.
Okay.
Right.
So we would say this is a breach of contract case in sum, and in terms of the trial court correctly relied on cases finding that the independent tort doctrine applies, and it applies against individuals in the fraudulent inducement context. And we would respectfully request that you affirm. Thank you.
Counsel for appellant, whenever you're ready.
Thank you, Your Honor. I want to start with the policy argument made by counsel, which is if this were the law and you can sue a CEO for fraud in the inducement, then there'd always be a fraud claim that goes along with a breach of contract when there's negotiations. First of all, if there's no fraudulent statement, that would never happen. So we would hope that an officer would not make fraudulent statements. But we also cited the 5th DCA case of Billington. And I think that lawyers are smart enough to come up with provisions like the one in Billington, where if you expressly disclaim that you're relying upon anybody else's representations, then you're waiving a fraud claim, well, the contract can certainly say that. Our contract does not say that. And so the sky is not going to fall if the court continues along the line of cases like Costa that allows an active participant in a fraud to be sued for fraud in the inducement. And that goes to my next point, which is this is a fraud in the inducement case. This is not fraud in the performance. This is alleged as a fraud in the inducement claim. Paragraphs 31 through 38 of the complaint expressly state that they relied upon these representations as to the availability, the current availability of $350 million that was approved. In reliance upon that, then they signed the contract. So it is a fraudulent inducement claim. It's crystal clear in our complaint that we're not suing for fraud in the performance. And this was a bait and switch. So the bait, of course, was we have the money right now. It is present, available for you. And that turned out not to be true. So that also is why the statements in Pruitt, I think, are applicable to this case when it comes down to the bait and switch aspect of the case. And then just finally, I do want to distinguish the case of Hotels de Key Largo, which was relied upon by counsel. And the distinguishing factor in that case, which it does say that if the contractual claim is interwoven with the fraud claim, then there's no fraud claim. But in that case, they were suing the same party. It was the contracting party that was being sued for fraud. And the court found, well, it's the same term that you're suing for the breach of contract in that same complaint or in the same contract. So you can't also sue for fraud when the express provision is also available to you in a contract claim. And that kind of goes back to my original argument, which is in Costa and the 4th DCA line of cases and the Southern District of Florida as well, which say that if you have an independent tort defense, you cannot apply it to a non-signatory to a contract, which is exactly who Mr. Galvin is in this case. So in closing, Your Honor, we would respectfully request that the lower court's order be reversed and the case be remanded for further proceedings on the fraud and the inducement claim as pled. Thank you very much.
Thank you, counsel. We appreciate your argument today and your briefing in this matter. We are going to hear our third case of the day now. Thank you.
Thank you very much. May we be excused?
Absolutely. Our final case of the day, if you guys want to make your way forward, is Work and Rust Inc. versus Geico Indemnity Company. It is 24-0717. While you make your way up, I'll introduce myself. My name is Judge Nardella. Joining me on the panel today is Judge Brownlee and Judge White. As I'm sure you all know, both appellant and appellee will get 20 minutes per time, 20 minutes to make their argument. Counsel for the appellant also has the privilege of rebuttal if they would like it. We typically reserve 5 minutes for rebuttal, but if you'd like a different increment of time, let us know and we can adjust it. Counsel for appellant, whenever you're ready, you may approach the podium.
Before I acknowledge. Can you hear me okay?
Yes, sir.
I went back and forth and I decided I should file supplemental authority today. And the reason I did that, because I thought it would be better than waiting till afterwards and filing it. So it was definitely short notice, but it was a result of me searching a different platform.
Thank you, counsel, for acknowledging that.
Myself, may it please the court. My name is Jack Callow. I represent Work and Rust Inc., which is a small company owned by Anna Lawberry. Her last name is pronounced Lawberry. I'd like to first address the answer brief of defendant, but also in light of the order of the court below. The answer brief of defendant went through several objections to preservation and just supposed failure to argue against the affidavit that was used in support. There were several items of evidence presented with the defendant's counter motion for summary judgment. Only one of those items, which was the affidavit of Thompson, only one of those items presented the facts on which defendant's answer brief depends, and that is mailing, specifically proper mailing. And that's why I'm arguing that at the same time as the order of the court below, because the order of the court below was based on proper mailing. Without getting into the detailed facts, which I know the court's already familiar with, this case involves a simple contract of insurance which named a lost payee lien holder, my client, Work and Rust Inc. They were named in the policy of insurance. When the insured vehicle was totaled, the insurance company made the proper contacts and told people they were mailing checks. My client followed up and requested mailing, didn't get a check. And the insurance company said to her, we mailed it. This is all laid out sufficiently in the opening, the initial brief. And I think it's also carried through in both parties' following briefs. But then Lawberry said, we didn't get it. And they said, well, we mailed it. They got a copy from the bank and sent that copy to her and said, our obligation's fulfilled. That's really the essence of the problem. We have some legal details and some legal arguments that contain a lot of different terminology, but it all boils down to someone stole your check. We're not responsible for that.
Is there anything in the policy that you could point us to that talks about whether the insurance company's obligation is discharged upon mailing, or is it discharged upon receipt by your client, or something else? It
No,
doesn't
there's
speak
nothing
to
in
that.
There's nothing in the policy that specifically says that. Pardon me, The policy does have a list of, and I didn't bring the whole thing today. It has a list of things in which we will not protect the lien holder. And they, that enumeration of 4 or 5 things basically express the holdings of previous cases. I couldn't name the cases, but the holdings of these cases have created these terms that Geico was very careful to specify. And but as to the answer to your question, no, it doesn't.
Yeah, I share Judge Brownlee's question. So we're here on a breach of contract claim,
Right.
right? Did the contract obligate them to pay you, correct?
Yes,
And that's in the, I'm sorry, the loss payable clause.
that's right.
How is that, per the contract, how is that obligation fulfilled? Is there any dispute that that obligation is fulfilled upon mailing, correct mailing?
There's
is it
no
fulfilled?
provision for mailing or any other means, just payment. And that's why when Working Rest filed its lawsuit, it alleged a simple contract. A contract, a obligation. and
Well, I guess in there, I mean, what they would argue is that payment was made, right? The address, although it may be in dispute, there was a check issued and it was issued in name to your company,
they contend that there's a check issue.
correct? And that's not disputed, is it?
It is disputed, but it's not a major dispute that is presented to the court today, but it's not acknowledged. That's part of
That the check, sorry, it's not acknowledged that the check was written
That
and
the check-
sent?
it's not acknowledged that the check was written or that it was mailed. For purposes of argument today, it's sufficient.
Hold on, counsel. Paragraph 1 of the court's order says the parties are in agreement that the defendant timely issued a check made payable to plaintiff for a mutually agreed upon amount.
That's correct. It's correct that the order says that, but that's not based on anything in the record.
Did you challenge this? What you're saying is a false statement of the parties' agreement and a motion for rehearing?
And I don't believe so. I don't believe it's challenged in the motion for rehearing specifically, no. But
it appeared for the first time, this error you're alleging on the face of this order.
yeah, and yes, and if you read the transcript of the hearing, there's one point where Working Rest Counsel specifically says that we don't acknowledge the check was created. And while that might seem a little bit unusual, the reason for that is because no evidence in this case came from Geico. Geico, they presented documents. The check that Geico presented in this case was obtained by Geico in a subpoena to Bank of America. It did not come from Geico's files. And there's no dispute about that. And that's just the record.
Yeah.
There's no, we spell this out in the briefs. There's no mailing receipt. There's no record of mailing in the files of Geico that's offered. There's no statement by the person that mailed or the person responsible for mailing. There's the statement by the Thompson affidavit, which is really the big issue.
Can you
She's the adjuster in the case,
I'm
correct?
sorry.
Go ahead,
Ms.
Judge Brown.
Thompson is the adjuster in the case?
No,
We do have an adjuster in the case, do we
that's
not?
another unexpected answer you know, to the court possibly, but no, Thompson relates things. She says that she's saying this on personal, making a statement on personal knowledge, but what she relates is what the adjuster did and what the adjuster said. She makes statements as to what the adjuster and Anna Lawberry, the owner of Working Rest, what they said and what they did. But she never says that she's the adjuster. She says she's the current adjuster.
The
And
what? I'm
The
sorry.
current adjuster.
Current
So
adjuster.
Elizabeth Thompson was a claims adjuster. And she provided an affidavit in this case that describes mailing.
she's a claims adjuster at Geico.
Is there any evidence that she wasn't the claims adjuster at all relevant times? I do understand that adjusters
In
change
her,
various.
yes, in her affidavit, she makes a few affirmative statements. one of which is paragraph 10, which says the check was mailed to 3470, which is not the correct address. She makes a few affirmative statements, but she makes a lot of statements, which I could read, but they're easy to find. Early in the affidavit, she says that Anna Lawberry gave her the address to mail the check to 3470 Old Winter Garden Road, Orlando. So it's pretty clear from the affidavit that she's relating that from the adjuster's record. One of the problems with the affidavit is that she doesn't say that Anna said this to me. She doesn't say anyone said it to her. She says Anna told the adjuster, or Miss Lawberry told the adjuster. And the adjuster said this, and the adjuster verified this. In the affidavit, in the early part, there are a lot of paragraphs to it. And I made a list of the types of statements that she makes. But what she never makes, Thompson never makes, is a firsthand statement of what she did and what she said to or from Miss Lawberry. She says the adjuster did this, the adjuster did that. And in fact, I believe she's referring to November 15th of 2021, as the day that it's one of the early paragraphs, maybe I think paragraph 7 or 8 of the affidavit of Thompson. She says that the adjuster, I think she said that the adjuster called Miss Lawberry, and Miss Lawberry gave her the address of 3470. It says that. That's the wrong address. But the next paragraph is the general practices paragraph. It says it's the general practice of Geico to mail the check, et cetera, to the address in the mail to field. She calls it the field, which gives the impression, she doesn't say this, but she gives the impression that the adjuster is working on a computer and input. She uses the word input. So the adjuster input the correct address in the mail to field. And the general practice is that the check is mailed the next day.
Counsel, we don't know that the affidavit was made. She does not tell us, the adjuster doesn't tell us the affidavit was made based upon looking at some log kept by all adjusters in the case, correct?
She makes a reference to the file of the adjuster.
But she says it's based upon her personal knowledge. We know she's an adjuster at some point in this case. Is it not speculation that this is not her personal knowledge?
Oh, no, Your Honor. I would represent, that's not my speculation at all. It's solidly shown in the affidavit that
She's not the adjuster, that there were other adjusters and she's, sorry, I'm sorry, counsel, go ahead.
that's part of one of the defects of the affidavit. She never says when she's the adjuster, but all we know is the affidavit was made in August of 2024, I believe it was, when the 2023, when the motion of some judgment was made. The affidavit was made, I believe, in July, about 3 weeks before the defendant filed their response, their opposition, and their counter motion for summary judgment. But I don't mean to be argumentative, Your Honor, but no, she never says that she was the adjuster on the claim. She never says when she became the adjuster. There's another document in the record of the court that she signed something that may be a discovery document, and the title, it says examining adjuster Elizabeth Thompson. But in this affidavit, she doesn't say examining adjuster. She just says she's Elizabeth Thompson.
Also, is it your position that an adjuster who comes on board later in time, say we just can't find that initial adjuster anymore, but say that insurance company is certain it mailed that check and it's certain it mailed it to the right person, is there never in your mind a way for the next adjuster to make a statement in support of the insurance company mailing the check? Like, there could a subsequent adjuster say anything in the affidavit that would be sufficient to demonstrate that the insurance company did in fact mail the check?
Well, the adjuster could say whatever the record shows. That's what she doesn't do here. She doesn't say that she's stating what is in a record. She doesn't say I'm reading the adjuster's file, but she speaks in the third person. about the adjuster. This is not the primary issue, and we believe that this case can be decided on the pretty much what the arguments are now. That Geico contends that it properly mailed the check. The order finds that Geico properly mailed the check. The affidavit of Thompson does not show that Geico properly mailed the check. She didn't say she mailed it. She didn't say who mailed it. She didn't say she even examined records, internal records of Geico that it was mailed. What she says is what the adjuster and Ms. Lawberry said to one another. And she asserts affirmatively, Ms. Lawberry said this, but she doesn't say she ever spoke to Ms. Lawberry. She doesn't say Ms. Lawberry said it to her. So I think that, well, I kind of I got my nose down close to the paper and really examined all these addresses in each paragraph of the affidavit. And so I'm very familiar with these details, but I don't believe that's essential for the court to make a decision. What the court is faced with today is whether the affidavit of Thompson was sufficient on the standards of Rule 1.510, Rules of Civil Procedure, which requires firsthand knowledge of an affiant who makes statements admissible in court. And the issue is whether her statements are admissible, whether her statements are firsthand. She starts out saying, I have personal knowledge, then she does not make firsthand statements, except for one or two. One is, it's paragraph 10, which says, paragraph, I think it was 8 says, Ms. Lawberry gave us the address 3470. Then it's the practice, that might be paragraph 7, and paragraph 8 might say it's the practice to input the address that given by the lien holder, party to be paid, to input that address in the mail to field. The next paragraph says it's the general practice to mail the check to the address shown in the mail to field. Doesn't say they mailed it to 3740, which is the correct address. The next paragraph says, in this case, the check was mailed to 3470, which is the wrong address. And one might assume, I don't think we should assume anything here, but one might assume, oh, that's a mistake. That's a inversion of numbers, except that she just relates that Ms. Lawberry gave her the wrong address. Then in paragraph 10, she says, in this case, we mailed the check to the wrong address. In other words, those addresses match. There's nowhere in the affidavit where Ms. Thompson says, Geico mailed the check to 3740 Old Winter Garden Road. She says, Geico mailed the check to the address she said it's the general practice to mail it to the address in the mail to field. I hope this isn't too confusing because it's not really what I think is before the court.
Counsel, when you began your argument, you appeared to concede that you may have a preservation issue, but it may be excused. Is that what but you didn't really develop why you brought up preservation. Can you do that?
Why I brought up what?
Preservation. When you started here today, you
Mhm.
said that my opponent is going to say or has said that some of these arguments are not preserved. Can you identify what you think they're talking about and why you think it doesn't
They're
matter?
talking about the argument that there's no proof, the absence of proof of mailing the check to the proper address. And that was preserved. And the reply brief sets out the pages. And it was preserved, and it was specifically the main argument in Workenrust's opposition to the motion for summary judgment.
What about the argument that the numbers and the address are transposed? Was that argument preserved? And does it need to be?
No, that argument wasn't specifically discussed below, but everything that composes that argument was. In the case of the Ruiz versus Wendy's trucking case that was cited by the defendant, in that case, the court gives a very careful articulation of why, I believe it's Ruiz, properly raised an argument without specifically raising the argument. They raised the legal point, but didn't articulate it in the words that were used in the objection. The court in that case said they did properly make that, they made that argument. That party lost for a different reason, but I would refer to that. It's almost a full page discussion of what it means to preserve an error when you don't use the typical words or the precise enough words.
But was there ever a moment where you informed the trial court, hey, judge, further proof of this mailing problem is based on the affidavit and this inversion of numbers? Like, do you think that that was brought to his attention at all?
Not the inversion of numbers was not brought to his attention. No, the numbers were only used once in the transcript of the hearing. And it was by Geico's counsel, but it wasn't on that issue. That issue seems to have slipped by, but I think that the competence of Thompson to make her affidavit and the failure of the affidavit to support their motion for summary judgment or to preclude Workenrust's motion for summary judgment, I think that's clear that affidavit cannot support the court's ruling.
Thank you, counsel.
Thank you.
If you can hold 1 second. Marshall Crawford, I'm having trouble. I don't know if I need to reset. It's not giving me the. Thank you so much. Counsel, whenever you're ready.
Thank you. May it please the court. Sharon Degnan here on behalf of Kubicki Draper, representing the appellee, the defendant below, Geico Indemnity Company. We're here today asking the court to affirm the summary judgment in Geico's favor. And we believe this case should be resolved primarily on the preservation grounds, since the main issue that plaintiffs argued, as made clear from the argument today, as well as in the reply brief, makes it totally clear that the issue that they're addressing regarding the address in the affidavit, it was never raised or ever brought to the trial court's attention. Now, this court just a few weeks ago in the Figueroa versus Universal Property case, I believe Judge Nardella and Judge White were both on that, as well as the Florida Supreme Court, and every court in this state recognized the impropriety of parties raising arguments for the first time on appeal, even of a summary judgment order. That's exactly what the plaintiff did here. And
Counsel, let me focus you on that. I heard appellant's counsel concede that this transposition of the numbers was not brought to the trial court's attention. But what about his argument that the affidavit was insufficient to show that the affiant had the competence to testify to what the affiant testified to regarding the mailing practices, et cetera? You're saying that wasn't preserved?
I think they did challenge the affidavit in that way. And they argued that unless somebody came forward with an envelope, that they were not qualified. And some of the arguments that we heard here today, that unless it was the person that actually sent the letter, that nobody would be competent. And we don't believe that's what the law is. So that issue was preserved, challenging.
The issue in whole as to Ms. Thompson's affidavit, I understand, but particularly today, that Ms. Thompson may not have been the adjuster at all times. Was that argument made below?
It wasn't worded that way. No, it wasn't. I mean, they never argued whether she was or wasn't. And, I don't know that the record even reflects that. It does talk about, though, that she has personal knowledge through looking at the claims file and being familiar with Geico's business practice of how it mails lien holder checks. And she lays that out very closely and talks about what was done and how it was done. And then looking through the claims file, that it was done in this case.
It's my understanding of reading this record that it is not clear whether mailing took place by the adjuster
who may have input the information and printed out an envelope and put it in the window, or whether it went to some mailing center after they input the information, and then the mailing center, which may keep a lot, like, we just don't know in this case is where I came away. Is that accurate?
Well, I think that paragraph 9 of the affidavit, deals with that. And it says, with respect to the issue of mailing checks, Geico's practice is to confirm the mailing address and any special mailing instructions with the lien holder before issuing payment. Once the mailing or special instructions are confirmed, the payment is issued. And then it goes through, the affidavit does talk about how the information is input through the adjuster, right? When they're
Right, but we
talking
don't
to
know
the
if that's
lien
taking
holder.
place in the adjuster's cubicle with the printer, printing it out, and then stuffing it, and then her giving it to the mail person, or if it's going to a mail center, which is doing all the mail for the adjusters that day. We just,
Well, it says, right, the check is then printed. I think you're probably right that it doesn't specifically say, it does talk about that the adjuster is the one talking, that's part of the practice to make sure you're sending it to the right place. And that's where the lien holder is instructing you to send it. And I think that's really an important point here, that's really what the trial court correctly was concentrating on, that there's no dispute that the check was sent to the lien holder when they told them to mail it to them at that address. And I think that's very important with respect to the issue of whether Geico complied with its contractual obligations here. Because under the policy requires them to pay the lien holder. And the question becomes, okay, well, what is payment? And that issue under Florida law, I think plaintiff's position is that it has to actually be hand delivered and reach the lien holder. And our position is that's not what Florida law says. What Florida law says is that if the parties come to an agreement where the creditor consents to payment by mail, then payment is made once the check is mailed. And that's why summary judgment was correct here. And that's, I think the trial court correctly found that. And so our position is that, the issues that have been briefed in this case are really, none of them were preserved. They're different issues. A lot of the issues that are being raised in this case are different than what was raised below. And the trial court correctly ruled based on the issues that were before him. No, one of the other issues, we haven't really discussed it here today, but one of the issues that came up are issues with the UCC. And again, whether Geico's obligations were discharged as a result of the check being cashed. And again, and I think that issue, as I was planning how to address this issue, I think it's important for two reasons. One, because there was a discharge defense raised by Geico saying, our duty was discharged when the bank cashed the check. But I think the big picture reason why that's important here is because this isn't a situation where Geico's saying, oh, we put it in the mail and it just got lost and it was never cashed. So sorry. If that was our position, I think it'd be a different situation. But the fact that this check was intercepted and was actually cashed by someone, that makes it an issue that also the question becomes, where is the remedy here? And our position is that the remedy is with the bank. And I think, that is another issue that's very clear in this record, that this whole dispute could have been avoided when these situations happen. Geico tells the party, if you fill out this fraud affidavit, and it's a Bank of America fraud affidavit that they require, and it's provided to the bank, they'll credit the money back from the person, because in this case, it went into some random person's bank account. If you sign that, it will be credited from their bank account back to Geico, and they would have reissued the check. I mean, it really could have been that simple here.
Is there anything in the record that states why that didn't happen?
Well, the argument is that they were being told that they shouldn't sign it because there's an indemnity provision in there that essentially says, if you're involved in the fraud, you have to indemnify us. I don't know that that's an unreasonable circumstance, but at the end of the day, the question becomes, you could have gotten the money back. And again, I think they'd be right if if the facts didn't show that the lien holder told us to send the check to that address, they may have an argument that there could be a breach of contract claim, but the law is very clear that if there's an agreement or the creditor consents to payment by mail, then at the time that the check is placed in the mail, they've complied with their contractual duty. And at the end of the day, our position is that that's why the trial court correctly granted summary judgment in this case. And the court recognized that there is a remedy here. So if the court doesn't have, hopefully my position was clear in the brief. If the court doesn't have any other questions, I'll rely,
Just one question following on what you just said. The trial court found that there was a remedy here. Do we have to find that there was a remedy for your client, an alternative remedy in order for your client to prevail on appeal?
I don't think you do. I mean, I think at the end of the day, you don't have to, although I think it sort of explains why everything that was done here is correct. And I think if you look at the different steps, it makes sense. But, plaintiff's position throughout this, they argued the UCC is irrelevant and it's a breach of contract claim and that they're required to get the money. And I think when you really boil it down the position, our position is that's not an accurate statement of law, and that where they agreed and consented to do it that way, that's the law, that once it was in the mail, we complied with our contractual obligations. So the court correctly granted summary judgment. Did that answer your question?
It did, thank you.
All right, thank you very much. We'll rely on our brief.
Thank you, counsel. I'm sorry, counsel, but you already went into your rebuttal time. So arguments are over for today. I thank you guys for your arguments today and for your briefs that were presented on this matter. The court is in recess. Or adjourned, actually.